Hi everyone, welcome to my channel. Part-3 of Indian Constitution is Fundamental Rights, deals with Articles 12 to 35. It has 6 fundamental rights. Right to equality deals with Articles 14 to 18. Right to freedom deals with Articles 19 to 22. Right against exploitation deals with Articles 23 and 24. Right to freedom of religion deals with Articles 25 to 28. Cultural and educational rights deals with Articles 29 to 31. Right to constitutional remedies deals with Article 32 to 35. Let us discuss articles of these 6 fundamental rights in brief. Fundamental rights in general deals with Article 12 and 13. Article 12 is definition of state. In this part, unless the context otherwise requires, the state includes the government and the Parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. But why it is necessary to define state? When we read constitution, frequently the word state comes. That's why it is necessary to define it. It is explained that in central level, parliament means legislature and executive means government. As well in state level, local authorities like municipalities, panchayat raj, etc. For example, if government hires someone to take trash of any particular state, then that comes under state only. The government involved in any matter, then it also comes under state. Article 13 is laws inconsistent with or in derogation of fundamental rights. Clause 1 and 2 of Article 13 gives the definition of law. So basically Article 13 says that any law which is inconsistent with fundamental rights shall be declared void. Now who declares that it is void? It is declared by Supreme Court. So therefore the power of judicial review is essentially steps from Article 13. According to Clause 3 and 4 of Article 13, laws include permanent laws made by the parliament and the respective state legislature will fall under it. Apart from that, all the ordinances that are promulgated by the president and the governor respectively fall under it. And the delegated legislations means executive orders such as bylaws, rules and regulations also fall under definition of law under Article 13. Right to equality deals with Article 14 to 18. Article 14 is equality before law and equal protection of law. Article 15 is prohibition of discrimination on grounds only of religion, race, caste, sex or place of birth. Article 16 is equality of opportunity in matters of public employment. Article 17 is prohibition of untouchability. Article 18 is abolition of titles, military and academic distinctions are however exempted. The trick to remember all these articles is egged out. E for equality, D for discrimination, O for opportunity, U for untouchability, T for titles. Let us discuss all these articles in brief. Article 14 is equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 14 treats all people same in the eyes of the law. This provision states that all citizens will be treated equally before the law. The law of the country protects everybody equally and under the same circumstances, the law will treat people in the same manner. There are two important terms mentioned in this article. First is rule of law, which states that no man is above law and that person is subjected to jurisdiction of ordinary courts irrespective of their position or rank. This concept is also seen in preamble where equality is mentioned. Second is equal protection of law, which states that like should be treated like discrimination is allowed but it should not be arbitrary and should be reasonable. Article 15 is prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Then how come caste-based reservation is constitutionally valid in India? It is because of Article 15. Article 15 says state cannot discriminate any citizen on grounds of religion, race, caste, sex or place of birth. Clause 2 widens the scope and maintains that no citizen shall on the said 5 grounds be discriminated by access to shops, hotels, tanks or anything that is specifically designated to use of the general public. Clause 3 provides an exception where special privilege can be provided to women and children. Clause 4 maintains that Article 29 Clause 2 cannot prevent state from making any special provision for advancement of any SCBCs, SCs and STs. Clause 5 states and Article 19 Clause 1 Clause D cannot prevent state from making any special provisions for SCBCs, SCs and STs in relation to admission to educational institutions other than minority educational institutions mentioned in Article 30 Clause 1, which was brought in by 93rd Amendment. Article 16 is equality of opportunity in matters of public employment, which allows opportunity for communities who are far away from administration. Clause 2 says that state cannot discriminate on 7 criteria including place of birth and residence. Clause 3 talks about reservation on basis of residence. Clause 4 state can make special provisions for ones that do not have adequate representation. 4 clause A added by 77th Amendment allowed reservation and promotion cause issue of consequential seniority addressed by Union of India versus Veerpal Singh and Ajit Singh versus State of Punjab that introduced concept of catch-up rule. 4 clause B deals with reservation on total number of vacancies of that year. Clause 5 allowed employed person to be a specific religion and said it does not violate Article 16 clause 2. Clause 6 added by 103rd Amendment allowed reservation for economically weaker section. Article 17 is abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. Untouchability means not touching the members of a particular caste. Is untouchability defined in Constitution? Answer is no. Untouchability is not defined in Constitution. Untouchability is available only at states or private citizens. The practice of untouchability is available in both state as well as citizens. Even the state cannot practice the untouchability in any form. Either to any of the citizens of India can practice untouchability in any form. If the enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Article 18 talks about abolition of titles. Title means a prefix or suffix attached to one's name. For example, Sir, Nawab, Maharaj, Rai Bahadur, Khan Bahadur, etc. Clause 1 says that no title not being a military or academic distinction shall be conferred by the state. Means military and academic titles are not abolished because in emergency situations it is easy to identify the titles. Military titles like Field Marshal, General, Major General, etc. and in academic like Doctor and other. Clause 2 no citizen of India shall accept any title from any foreign state. It makes it illegal for an Indian citizen to accept any title from a foreign state. Clause 3 says that non-citizen of India holding any office of profit or trust under the state, then without the consent of the president he can't accept any title from any foreign state. In clause 4 as well, if a person holding any office of profit or trust under the state, he can't accept any present, emolument or office of any kind, form or under any foreign state, right to freedom without the consent of president. In next video, we will discuss the remaining articles of Part 3 of Indian Constitution. Thanks for watching my video. Please do like, share and subscribe my channel for more videos.